Okay, so I'm recording the class. As you might have noticed, I am uploading the class recordings onto YouTube. That I think is the easiest way for students to be able to subsequently access them. The YouTube links, once I've uploaded onto YouTube, I will share the YouTube link on e-learning. So I'm not necessarily going to post it on the group every time. It will be available on e-learning. The e-learning site is totally updated. If you haven't had a look yet, everything that you possibly need is available there. The study guide has been, please keep your, people, please keep your mics muted. All the study guide chapters are in one section together. Then you will also see that the e-learning site has been divided into different groups, different weeks, sorry. Weeks are numbered according to your course outline. If you click on the relevant week, you will also find all the study material pertaining to that particular week. The units of the study guide, the slides, I will be adding the recordings of the lectures, the link to the YouTube link to the recordings of the lectures, everything on there. So please make use of your e-learning platform. It's part of your learning experience that we provide you with the e-learning platform. So you should visit it regularly and see if I've added more stuff or etc., etc. Okay, so last week, not last week, on Monday, we did Unit 4. Now we are going back to Unit 3. As I explained, I decided to swap the sequence because maybe it would be easier, or I thought it would be easier for you to understand Unit 3 if we already know about the constitution of a company. To refresh your memories, the constitution of a company is comprises of 2 documents that are registered with the registrar of companies. Once these documents have been registered, the company is said to be incorporated. And then it is a juristic person with legal personality. Quick thumbs up. Can you see the slides? Okay, the slides are visible. Great. So you learned on Monday, Sydney, your hand is up. Do you have a question?
Ma'am, that was by accident. I wanted to just throw thumbs up.
Okay. Thank you, Sydney. There's one student here that said she can't see the slides, but it appears like the majority of the students can. So then I suggest maybe you should just log out and log back in. Sometimes it's just a connectivity problem on your side. So the constitution of a company consists of 2 documents. The memorandum of incorporation, which is a 1-page document containing certain important information. It is the founding document of the company. The second part of the constitution is the articles of incorporation. Articles constitute the rules pertaining about how the company is to be managed with regard to meetings, etc., etc., etc. An important thing that you have to understand about the study of company law, you need to start realizing it now, is that company law is a whole with introduction to law for accounting. To a certain extent, the units were separate. They stood on their own, but company law forms a whole. So for the study of further units, I will rely on your knowledge of what you did in units 3 and 4. So if we get to unit 8, for example, there will be references, the incorporated, knowledge incorporated, that I taught you now in units 3 and 4. Later in the semester, when you write test 2, for example, which is from unit 9 to whatever, in that test, even though it's from unit 9 onwards, you will be having to use knowledge that are in the earlier units. And you cannot then in that test say, but miss, it wasn't in the scope. Because everything, it's like a network. Everything fits together, which is also why it's so important that you stick with me, that I don't lose you at this stage. Because if I've lost you at unit 3 and 4, by the time we get to units 9, 10, 11, you'll be on saving. Okay, so types of companies. Your learning objectives, always important, always after you've gone through the unit, revert to your learning objectives and make sure that you can address all of them. So before I go on to my further slides, my first question for tonight. So hands up quickly, or somebody can just shout out. There are two main types of companies. What do you think? What are the two main types of companies?
It's a public and a private.
Thank you very, very much for that answer. Sydney, thank you for answering. That is exactly the answer that I was hoping for. However, Sydney, that is not correct. But I was hoping you were going to give that answer so that I can tell you you're not correct. Because I'm pretty sure everybody in the class, else in the class, also thought that your two main types of companies are public and private. But no, your two main types of companies are not public and private. Your two main types of companies are companies with a share capital, companies that issue shares, and companies that do not have a share capital, also known as companies limited by guarantee. And I'm sure now that I have pointed that out to you, that in fact, these are your two main types of companies. You won't forget it again. Companies with shares and companies without shares. There's a quick flow chart for you. Your two main types of companies are companies with a share capital and companies limited by guarantee. Your companies with a share capital, Sydney, there you were correct. Companies with a share capital are divided into two main types, namely private and public. Companies limited by guarantee, companies without a share capital, are very rare. We don't have that many of them. They are hardly ever used for business purposes. The main instances where you will encounter a company without a shareholding is with your non-profit companies. We will get to those later in the lecture. So companies with a share capital, without a share capital, private companies, public companies, and then there's a special type of private company, namely a Section 60B company, that we will also be looking at. So your main type of company, or one of the main types of companies, companies with a share capital. Theoretically, these companies obtain their capital by issuing shares to shareholders. Now, in practice, that is not always true. That dates back to the origin of companies. If a particular businessman, let's say Jackson, once has a business idea and wants to start this business, but you all know that it takes money to make money, and Jackson doesn't have the money to get this business going, what would he do? He would register a company and sell shares to other people that believe in his idea to raise capital. In practice today, that's not what's going to happen. Jackson is still going to register a company, but not for the purpose of raising capital, but for the purpose of having the protection of the juristic person. And then he's going to go to the bank and take out a loan to start his business. But traditionally, companies obtain their capital by issuing shares. Why would people that believed in his business idea be prepared to buy shares in his company? Because they stood the chance of making money, but with very little risk. Because of the juristic person, the separation between ownership and liability, where the company itself is liable for its debts. In most instances, I say normally because there might be exceptions, but in normal instances, these shareholders stand to lose no more than the money paid by them for their shares. So if Jackson sold shares to Nathan, Sean, and Alicia, and they each paid $1,000 for their shares, and unfortunately, despite his best efforts, the economy is against him, there's a drought in the company, Jackson's business fails and runs into debt. Sean, Nathan, and Alicia will only lose the $1,000 that they paid for their shares. But if the company has got a $500,000 debt by the time it finally collapses and is liquidated, they only lose their $1,000. They're not liable to have to pay in to cover for that $500,000 debt. As I've said, companies with the share capital divided into two types, public companies and private companies. Now, something you need to understand for the purpose of the rest of the semester is that the Companies Act that we are studying is written for public companies. It's written for public companies. How must these companies be run? What are they required to do? And then it makes exceptions for private companies. So it will say a company must do A, B, and C. Unless it's a private company, then it doesn't have to. So Companies Act written primarily for public companies. making exceptions for private companies. It is important, listen to me carefully, people. It is important that when you start doing case studies or answering questions in assessments, that you must always take note of the type of company that you are dealing with. Precisely for this reason, because in certain case studies, in certain instances, and I will point these out to you as we go along, just warning you now, but in certain instances, your answers will differ depending on whether the company in the case study is a public company or a private company. So public companies then, in brief, must have at least 7 shareholders, a minimum of 7 shareholders, no restriction on the total amount. It can have hundreds of shareholders. With reference to what I just said about always remembering or being aware what type of company I'm dealing with, I'm referring to in a case study. You identify a public company by the fact that the name ends with limited, sometimes abbreviated as L. It's a bit difficult to write like this, but LTD. So if you see a name with LTD or limited behind it, you will know this is a public company. Because it's a public company, shares are freely transferable. Any person, any member of the public may purchase shares. No restriction on who may buy shares, who may be shareholders. You can freely deal with your shares, etc., etc. In order to protect these shareholders, we're going to get back to this again at a later stage in the syllabus. But in order to protect these shareholders, remember, I started off in Unit 2 by explaining to you the separation between ownership and control. The shareholders are the owners, but the board of directors manage and control the company. So they are controlling the property of the shareholders in order to protect these shareholders. The Companies Act, and you're all studying accounting, so you should be aware of this, contains comprehensive provisions regarding the compulsory disclosure of information, publication of annual financial statements, etc., etc., so that the shareholders are always informed about what is happening with their property. Public companies, shares and debentures may be listed or dealt with on the stock exchange. Note, may be listed, not must be listed. It's not compulsory that a public company must be listed. There are various public companies that are not listed. I can give one example. I read about them in the news today. Althover and List Limited, which is the holding company for various other companies. Althover and List is a public company. It's Althover and List Limited, but it is not a listed company. One of its previous subsidiaries, which they recently sold their majority shareholding in, but one of their recent subsidiaries was Namibia Breweries, which was a listed company. So public companies, name ends on limited, any number of members, and you can freely sell your shares. Comprehensive provisions regarding compulsory disclosure. Private companies. Now, only a company with a share capital can be a private company. If we go back to this flow chart, companies limited by guarantee are public companies. A company limited by guarantee can never be a private company. In order for a company to be a private company, it must have a share capital. How do you recognize it? It's a Pty limited. So public company, just limited. Private company, Pty, proprietary limited. Always be aware of what type of company you are dealing with. Number of shareholders. This is a strange provision in the Companies Act. Companies Act says that a private company must have at least 2 shareholders unless it is a private company with only 1 shareholder. So minimum number of shareholders, 1 or 2. If I can just interrupt myself here quickly, you might have picked up that I'm using the term member and shareholder interchangeably. For the time being, I'm going to refer back to that at a later stage. But for the time being, these 2 words have the same meaning. So whether you refer to a member of a private company or a shareholder of a private company, it's exactly the same. You cannot be a shareholder without being a member, and you cannot be a member without being a shareholder. Now, as I explained, Companies Act written for public companies. Private companies, exceptions are made. And one of those exceptions are that they are excluded from the strict disclosure requirements expected of public companies. There are still disclosure requirements. They must be audited annually, etc., but not as strict. There are some exceptions made, some things that private companies don't have to do. Now, how does a company become a private company? When it is registered, the following 3 provisions must be included in the Articles of Association. Remember, I pointed out to you 2 documents, memorandum, articles, and you need to know which information goes where. If you're not sure, if in doubt, leave it out. So if I ask you, how would you identify a private company? And you say it must include in its constitution, that would be correct. Or it must include in its articles, that is correct. But if you say it must include in its memorandum, that is incorrect. So always be certain. If you're not sure which one of the documents to refer to, then just go for constitution. So there are 3 things that have to be included in the articles of a company. The first one is a restriction on the right of the free transferability of its shares. Public companies, shares are freely transferable. Private companies, they are not freely transferable. In its articles, there must be some provision which limits. There's a student here that has a problem with seeing the slides. Is she the only one that is struggling to see the slides?
I also have a problem, ma'am. It says you can't view the PowerPoint. I don't know why.
O'Brien, are you also struggling to see my slides?
Yes, ma'am.
Okay, I'm going to stop sharing.
Me too, ma'am.
But you can hear me okay. Okay, I'm just going to share again. I've just stopped sharing and I'm just going to try again.
I think if you are using the phone, then it will say you need to update your Teams to a new version for your phone. Then it will maybe show.
Okay, I'm struggling to share now. It seems not to be uploading. I don't know why it isn't sharing now. Okay, just bear with me. Now my slides won't share at all. It starts sharing and then it kicks me out. Because I really don't want to. Okay, I'm going to try something else.
What if ma'am ends the meeting, then she restarts it?
Yeah, I just want to try something else quickly. Okay, can you see it now?
Yes, ma'am.
Yes, ma'am, I can see it.
Yes, we can see.
Okay, so I've shared with, sharing in a different manner now. Now you must just be aware that I can't see the class. So as in the past, as in last semester, if you want to stop me for a question or something, please just interrupt, just speak up, because I've now got the screen with the slides in front of me, as opposed to the screen with the class. Right, let's carry on. Let's not waste, because there's quite a lot of work that I want to do tonight. So let's not waste time. PTY Limited, words end with, so you can recognize it with the name will end with PTY Limited. We're looking at this part. A restriction on the right for the free transferability of the shares. Public companies, shares are freely transferable. Private companies must, in its articles, have a provision that restricts the free transferability of its shares. The Companies Act does not prescribe the format of this restriction. So it can be anything. It can be a provision that shares may only be sold with the consent of other shareholders. Shares can only be transferred with the consent of the board of directors, whatever. As long as there's something in there which restricts shareholders' right to freely transfer their shares to other people. There must be in its articles a limitation on the number of members to a maximum of 50. That is self-explanatory. And there must also be in its articles a prohibition on offers to the public to the subscription, for the subscription of its shares or debentures. Public companies, shares and debentures are freely transferable. Private company, this is forbidden. This does not mean, people, that a private company may never sell its shares to somebody else. What it rather means is that there may not be offers to the public. You may not advertise the shares to random members of the public. You cannot place an advertisement in a newspaper saying, come and buy shares. But if for example, Laimi and Roberta are our two shareholders, and they would like to bring Julia in as well, and they approach her and ask her, but does she want to become a shareholder? They are allowed to invite her if it's a private invitation. So the restriction on inviting shareholders means you cannot advertise it to the public. You cannot make a random offer to people that you don't know. Public companies often, if they are planning expansion and want to raise additional capital, they can decide, okay, they are now going to issue so many thousand new shares, and they advertise this, and any member of the public can come and buy shares. Private companies may not do that. They may, however, approach an individual, go to Aronisia and offer to her to become a shareholder. So don't confuse those two aspects, please. So in order for a company to be a private company, those restrictions must be included in its articles. Now we get a particular type of private company known as a Section 60B company. Word of warning here, I do not expect of you to remember the specific sections of the Companies Act unless I tell you to. And this is one of those cases where I'm telling you, you have to remember section 60B. Just section 60 on its own is not correct. Section 60B, because that is the name of the company, so to speak. So what is a section 60B company? It is a professional company, most commonly used by legal practitioners, lawyers, who, in terms of their founding professional legislation, sorry. The company is a juristic person, which means the shareholders and the directors are not held liable for debts. In terms of the professional legislation, the members of this professional firm may not avoid personal liability. So now you're sitting with a quandary. There are certain reasons why they would choose to be incorporated to be a company, tax reasons, perpetual succession, etc., etc. But because of the concept of the separate juristic person, they run into problems with their founding professional legislation. Now, a Section 60B company is a way of overcoming this. You recognize a Section 60B company because the name ends in incorporated or Inc., I-N-C, instead of Pty Limited. Always be careful. Is this a Pty Limited? Is this an Inc., an incorporated company? Incorporated professional company contains in its memorandum or in its constitution, that's just as well, just as good, but not in the articles, in the memorandum, that the directors and former directors of the company will be jointly and severally liable for the debts and liabilities of the company which were contracted during their periods of office. I trust you will remember the concept of joint and several liability. You should know what that means because I taught you that when you were doing introduction to law, when we did partnerships. I explained to you the meaning of the term joint and several liability. Now it means exactly the same here. So either the one or all of them, or the company itself. Directors and former directors shall be jointly and severally liable for the debts and liabilities of the company, which are or were contracted during their periods of office. Let's just explain that quickly. So let's say here that Nathan, Sean, and Jackson, these are just the names that I have in front of me. Nathan, Sean, and Jackson are the directors of the company. Any debts contracted by the company while they are the directors, if the company doesn't pay, they can be held liable. Any one of them or all of them together. Doesn't exclude the company from liability, but if the company doesn't have money, a creditor can look at them. If Julia subsequently joins the company, she will not be liable for any of the debts before she came director. Her liability only starts when she becomes a director. If Nathan now decides to resign, he will not escape liability, but he remains liable for any debts that were contracted while he was a director. Important to note, oops, sorry, wrong slide. Important to note that this provision, making them jointly and severally liable, applies only to contractual debts and liabilities, but not to delictual liabilities that arise from the law of dealing, damages claims, or statutory liability, for example, income tax. Joint and several liability, any one of the directors can be held liable. If such a director has paid those debts, he or she will then have a right of recourse, a claim to get the share back from any other directors that did not pay at the time. Make a note of this bit. This is a section of the work that I do frequently bring into assessments. So those are your companies with a shareholder, with a shareholding. Public companies, companies with a share capital, public companies, private companies, and a special type of private company is your Section 60B company. The other type of company is companies limited by guarantee. I just want to get to the right slide here. Companies limited by guarantee are public companies. They are always public companies. Company can only be a private company if it is a company with a shareholding. Because it is a public company, at least 7 persons are required for the incorporation of the company. They do not issue shares. Now, I explained previously that with a private company, the shareholders stand to risk to lose. Oh, let's go to that slide. Members stand to lose no more than the amount paid by them for their shares. Private company limited by guarantee does not issue shares. So they do not pay to become shareholders because they aren't shares. There must be some form of liability. How does their liability work? In the memorandum of such private company limited by guarantee, there will be a statement in terms of which the members of this company undertake, if the company is liquidated, if it is wound up, they undertake to contribute a certain amount, to pay in a certain amount, which can then be used for the purpose of paying the debts. The way the Companies Act is phrased, however, is that there is a limitation. So it's not an open-ended that, okay, now there's $1 million debt and these 7 members have to share this $1 million debt. They undertake to contribute a certain amount, a certain fixed amount. Companies Act says that they must undertake to contribute a certain amount which may not be less than $1 per member. Doesn't say how much it must be. Doesn't say it must be X. It just says it must not be less than $1. This provision dates back from the early Companies Acts. I think our first Companies Act was dated 1948. And then the one after that was 1973, where R1 at the time was a lot of money. In 2004, when our Companies Act the Namibian Companies Act was adopted by Parliament, was written and adopted by Parliament. They simply changed the reference from rand to Namibia dollar, but they kept it on $1. They didn't increase the amount. So obviously what happens is that these members undertake to contribute the amount of $1. You can think for yourself that it's a pretty meaningless provision, because if there are 7 members and they each contribute $1, that gives us $7, which is not going to go very far towards paying the debts of the company. It is a public company, so it must lodge annual financial statements, etc., etc. Same provisions that apply to public companies that have a share capital. How are you going to recognize them? The name ends in limited, and then in brackets, the statement limited by guarantee. Now, we don't get very many of these. They are very, very rarely, if never, used for trading purposes. Only instance where we will, in real life, encounter a company limited by guarantee is with your non-profit association, your sections 21 company. You also need to remember section 21. So there's now 2 things you have to remember, lots of things you have to remember, but 2 sections of the Companies Act, section 60B and section 21. It is a company limited by guarantee, so it is a public company, always. Any other form of company, so private company with a shareholding or public company with a shareholding, may convert into a non-profit association, but not otherwise. A non-profit association may not convert into a company with a share capital. We will learn shortly why the Act contains that provision. How do we recognize them? Because the name ends with the words non-profit association incorporated under section 21. So what are the requirements for a non-profit association? Firstly, the main object of this company must be the promotion of religion, arts, sciences, any charitable object. So not business, but some charitable object, religion, arts, science, education, you name it. It must intend applying all its profits, if it makes any profits, and any other income in promoting the main object of that company. So the fact that it's called a non-profit association doesn't mean it may not do business, doesn't mean it may not make money. Schools, for example, are often registered as non-profit associations, private schools. They charge for learners to attend that school, so they are making money. But that money does not go into the pockets, into the bank account of the members, but it is applied towards education. That does also not mean, don't get this wrong, it doesn't mean that the teachers working for that school may not earn a salary. Even if they are members, they may still earn a salary for services rendered, for work done, but they cannot share in the profits. The constitution of the company must also prohibit the payment of dividends. The term dividend is a term used for profit sharing. When companies share their profit with the shareholders, we say they are paying out dividends. Company must reapply its profits or any other income, donations, etc., to promoting its main object, and profits may not be shared to the members. No payment of dividends. The memorandum of this company must include the following provisions, which is largely a repetition of what I've just said. Memorandum must provide that income and property shall be applied solely towards the promotion of its main object. No portion thereof shall be paid to the members of the association. And upon its winding up, deregistration or dissolution, any remaining property, any remaining assets shall be transferred to some other association with similar objects to its main object, so not to the shareholders, the members. So getting back to that provision where I said that a non-profit may not be converted into a company with a share capital, that is to avoid the fraudulent use of a non-profit association. Donors are often, they give if they support the cause, they give donations to this non-profit association. Non-profit associations can sometimes have quite a large income. Reason behind that statement that it cannot be converted is to prevent a situation where people have registered a non-profit and now there's a lot of money in the bank account and they want their greedy little hands on it. And to prevent them now suddenly abusing the fact that people gave this money for charity and now suddenly converting it to a private company so that they can get their dividends, etc., etc. To prevent that, hence this provision that it cannot be converted. Once a non-profit, always a non-profit. Before I go on, any questions so far? Are you quiet because you're confused?
I have a question.
Yes, Julia.
Can a non-profit organization be converted into another non-profit organization?
You can change the object, yes, as long as it remains. So if it was registered originally for the purpose of education, you can change the object to religion, religious, whatever, that you can do. I don't really know why you would want to do that rather than just registering a new one, but legally, yes, you can, as long as it remains a non-profit and the conversion does not have the effect of the assets of the company going into the pockets of the members.
All right, Miss.
Adonisia, are you with us?
Yes, ma'am, I'm with you.
Sydney?
Yes, ma'am, I am.
Sean?
Yes,
Checking
ma'am, I
up
am.
that everybody, just checking up on you that you haven't just logged into the class, but you're busy playing games on your phone or something. So everybody is with me. Okay, great. Then there's one more type of company that you need to know about, which isn't actually a type of company as such, because it can be either a private company or a public company, but you do need to know about external companies. An external company is a company which is registered in a country other than Namibia. So South Africa or Angola or Botswana or wherever. Non-Namibian companies, there is no restriction apart from normal tax implications and customs and etc. But in terms of the Companies Act, there is no restriction on a company which is registered outside of Namibia doing business with Namibian companies. When a company which is registered outside Namibia establishes a place of business, they set up and open an office here, or they engage in a transaction in Namibia, they will be known as an external company, and that's the only time they become relevant to Namibian company law. Important provision, well, how are they relevant to Namibian? How does the company law apply? If there's an external company doing business, having a place of business in Namibia, there must be a person resident in Namibia authorized to accept service of process and other notices. Doesn't have to be an employee, it can be their accountants or a lawyer or somebody. But in the event of then, for example, getting involved in litigation and a summons needs to be served on them, there must be a person or persons resident locally on which the court can serve that summons, so that they don't have to make all sorts of complicated arrangements to have summons served in Angola or Botswana or whatever. How are we going to recognize them? The name will end in incorporated in wherever they are. Remember, listen to me carefully now. You should know by now that, before I say this, Sydney, your hand is up. Sydney?
Yes, ma'am. Just a question. Deloitte, the company Deloitte, now, the professional auditing, accounting company. So, in this case,
Sorry, Sydney. Sydney. Can you start over again? I just turned my volume up. I wasn't hearing you. I've got to.
okay. Okay. Like Deloitte, ne? I think it falls under the Section 60B category in terms of companies, in terms of profession and all that. But it's like known all over the world. Does it also falls under an external company? Because I think I that company, I don't know if it's I think it's a multinational company, of course, but does it also fall under external companies?
Sydney, Deloitte is not a company. It's a partnership.
It's not partnership.
Deloitte,
Oh,
the
okay.
accountants, is an international partnership. If I can take you back to what we did in Introduction to Law last semester, right at the beginning of partnerships, we learned that there are certain professional partnerships that are exempt from the limit of 20 persons, 20 partners. Do you remember that?
Yes, but I can remember that usually they are exempt to, but like you say, ma'am, they are partnership, but um, at the end of the day, when it comes to 20 or more, usually the partnership will change to a company. Is what isn't it the large?
No, 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 no. Whoa, 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 whoa. You on the right track. Let's just get the details here.
Okay.
If it's an ordinary business, not a profession like accountants or lawyers or whatever. If it's an ordinary business, they run a shop or have a fishing business or whatever. The moment it exceeds 20, it has to register as a company.
As a company, yes.
It must register. Certain professions, like lawyers and accountants, are exempt from registering. So they can continue as a partnership even if they are more than 20 partners. And all of these large accounting firms are partnerships, not professional companies. So they have more than 20 shareholders because they are multinational. They've got shareholders all over the world, more than 20, but they are not a company. They are a partnership.
No, I just wanted to confirm that.
Yeah, no, very, very, very interesting question there. I really, Sydney, I enjoy having you in the class. I enjoy your questions because it shows me that you think wider than just on the slides. So I enjoy our discussions. Please keep them up. And if I need to sort of correct you on your understanding, sometimes that's how we learn. So please don't stop your questions. But Deloitte is a partnership. PwC is a partnership. EY is a partnership. All these large accounting firms are, yes, Aranisha, all audit firms are partnerships, not companies. Okay, on that note, because this is interesting, because there are also large law firms that are Section 60B companies. Whether they will be regarded as an external company or not will depend on where the actual company is registered. So if it is registered in South Africa as an incorporated, but it has a branch in Windhoek, it will be considered an external company because it is registered in South Africa. If it is registered in Namibia and it has a branch in South Africa, it's not an external company, it will be an external company with regard to South African law. So whether it's external or not will depend on the place where the actual company is registered. Okay, that's it for today. I hope that made sense. Thank you for the questions here towards the end. Any further questions?
I have one question.
Yes.
In relation to external companies, it was mentioned that there are no restrictions in terms of external companies registered outside Namibia. What I wanted to understand, especially it's from an angle of verification, because for a company, if it's registered outside the country, is there possible means in terms of verifying their registrations? Because the ones that are registered locally, they should be easy to verify through BIPA. But now for an external company, are we not risking ourselves into maybe engaging into business with entities that we cannot verify their registration?
Mr. Mapenzi, if you're a businessman, very, very good question, interesting question. If you are a businessman and you're about to enter into a multi-million deal with an external company and you do not make the effort to verify them, you should not be a businessman, because then you're stupid. But unfortunately, no, we cannot verify them in Namibia. You will have to then, if they are registered in South Africa, appoint somebody, a lawyer or somebody in South Africa, to verify them for you. Like similarly, somebody in South Africa who wants to do business with a company registered in Namibia will, before they enter into this deal, appoint a Namibian lawyer or accountant to do due diligence and verify them at BIPA, etc., etc., etc. So they can all be verified in their individual companies, individual countries. But no, it might cost a little bit of money to appoint somebody to do your due diligence for you. But if you don't do that, you shouldn't be going into a multi-million deal. Because yes, there are swindlers out there. Okay, Aronisia, my darling, will there be revision classes? Of course there will be revision classes. I know I'm going fast at the moment because the syllabus is packed and I have to keep up. But there will be revision classes. Yes, don't worry. Don't worry. I will not desert you.
All right, ma'am.
Thank you, ma'am.
Any further questions? Okay, today's been a long class. Sydney, your hand is up.
Last question, ma'am. I went through a couple of question papers regarding this module. Will there be calculations in the head when we go through the module? Because I see that you need a calculator in the examination.
Yes.
Okay.
Yes,
Okay.
when we get to Unit 8,
Okay.
shareholders meetings, you need to calculate voting
All right,
majorities and things like that. They are all fairly simple calculations. I've never understood why accounting students need a calculator to do them, but apparently accounting students can't calculate a quarter of 4 without a calculator. So yes, well, you will be getting, we will be getting to the calculations. Just be patient. What is a quarter of 4? Sydney, what is a quarter of 4?
A quarter of 4. 16, man. No, I don't know.
Come on, can somebody help Sydney out?
1.
Thank you, Sydney. Yes, Sydney.
You are right. We can't calculate quarter of 4. You are right, ma'am. We can't.
Yeah, Sydney, you just proved my point. You're an extremely bright young man, but you can't calculate a quarter of 4 in your head.
It's just one of those. It's just one of those things, man. That it's sometimes you can. Sometimes you just think to yourself, like, really, it's such a simple thing, but sometimes it just comes up.
But yes, I will be allowing you to use your calculator to calculate a quarter of 4. Okay, thank you so much for the class. The slides, the notes, everything are on e-learning. I'll also upload the lectures in the course of tomorrow. Listen to my lectures again. I find it interesting since I've been uploading the lectures onto YouTube. I can actually see how many views I've had. So it's good to see that people are downloading and viewing the recordings. Just a question, do you find it easy to access the videos on YouTube?
Yes, ma'am, it's very easy. And I also subscribe to that channel. So I
thank
get
you.
notifications when you post another video.
Oh, thank you, Alicia. So I have a subscriber. I have 3 subscribers. I'm a YouTuber. Don't think I'm going to not about to give up my day job and become a full-time YouTuber, but yes. Yeah, so if it makes it easier for you to access the videos that way, then I will continue doing that. Okay, thank you so much. Have a wonderful evening further. Bye.
Thanks, ma'am.
Bye-bye.
Bye.
Ma'am. Bye, ma'am.
Bye.